gosh.
Where am I going?
Okay.
No, don't start yet. I want to pump my seat
She
up.
wants
How
to
do I
pump
get-
her seat up
How
first.
do I get up? Oh, I've gone down again.
Yeah. Get off it. Pull it up.
There you go.
Yeah.
I went to the floor.
Yeah, but your feet don't touch the floor now.
Don't tell everybody that.
Okay. Are we ready to start then? Okay, thanks for that. Before I do start, I need to read something out to everyone who's here. May I remind everyone present that this meeting will be broadcast live via the internet and the record is archived for future viewing. So we all know that we're all live to many thousands of people who watch it from home. Yes. So, today, Thursday the 30th of March, welcome to all the members, to the Planning Committee and the members of the public, of course. Can I first of all start by asking for apologies for absence? I know Howard Hamilton was...
Yes, thank you, Chair. There's been 2 apologies from Councillor Hamilton and Councillor Preston.
Lovely. Okay, we note those apologies. Going on to the minutes of the last meeting, is it okay for me to sign those minutes as a true record?
Yes.
Thank you. We now need to receive declarations of interest under the Council's Code of Conduct from members. And the first one with his hand in the air is Andrew Parker.
Yeah, thank you, Chairman. 9-2 Lanark Vineyard, I would withdraw on that item.
Thank you. Councillor Burnett.
10 planning application 2016 stroke 01330 stroke RG3 Cosmeston Medieval Village. I have a personal and prejudicial interest as I'm cabinet member for the service, but I have taken advice. I am allowed to speak. I will then withdraw.
Okay, thank you. That being said, any more? No? Okay then. Moving on to agenda item 4, site inspections. If I ask the planning officer, is there anything to add?
Nothing to add.
They are nothing to add? No, we report.
Yeah.
Okay, thank you. Agenda item 5, which is building regulation applications other than building control matters determined by the head of regeneration and planning under their delegated powers. Anything to add to that,
Nothing to
Victoria? Move we note? Thank you. 6 is planning applications determined by the head of regeneration and planning under their delegated powers, which appears on page 9. Anything to add to that, Victoria?
Nothing to add, Chair.
They are. Move we note?
Yeah.
Thank you. 7 is appeals, which is found on page 20, and we've got the appeals officer here, Justina Moss, and I think Justina might want to lead us through.
Thank you, Chair. There's 2 planning appeals that have been received since the last committee. One is for the United Reformed Church and the other for Medvale Nursery. The decisions to report are, there's also 2 of those. Land adjacent to Pond Villa, which was dismissed, and the inspector agreed with the councils with regard to concerns about the impact on the heritage assets. However, their conclusions with regard to our requirement for affordable housing are disappointing. However, it is important to note the matters have again moved on since that inspector made that decision, and we are still taking the same approach with affordable housing and our requirements in line with the local development plan and our new SPG. And we think we have sufficient justification in doing that in light of the local development plan inspectors' lack of concern, if you like, regarding those matters. Obviously, all we're waiting for now is the LDP inspector's binding report. As for the bus depot at Toynerodin, that appeal was allowed. Obviously, our concerns with regard to that were in respect of its location, in terms of proximity to day-to-day facilities, and the fact that it was, whilst in fairly close proximity to Culverhouse Cross, it was along a country lane with no footpath or street lighting. The inspector noted our concerns and recognised that it doesn't strictly accord with local and national policy about development being in a highly sustainable location, but gave merit to the fact that this was a 100% affordable housing scheme, and she, in her conclusion, she weighed in the balance the need for affordable housing balanced against the sustainability of the location of the development, and found in favour in view of the need for affordable housing. Other than that, our appeals statistics remain disappointing for this year, and hope that inspectors will more favour our decisions in the forthcoming year.
Yes, okay. There was some for and some against. I know it was a difficult decision, but the inspector ruled against us. So, okay. Anybody else want to add anything? Otherwise, we'll move straight on. No? Okay. Thank you. So we're now on agenda item 8, which is the delegated list for trees and the little I, which is found on page 26. Anything to add, Victoria?
Nothing to add, Chair.
Nothing to add? Move we note? Yeah. Okay, now we move on to enforcement action, which is on agenda item 9, page 28. First of all, I'm going to ask Justina to give us an update on that update and progress report, which I think was asked by Councillor Bird. Yeah, there we are.
Thank you, Chair. This report was prepared in response to queries that were raised at the last committee. What we've tried to do is give an update with regard to the enforcement notice that are still live and haven't been complied with, and what's happening with those, in addition to the enforcement action that was authorised at the last committee. I'm happy to take any questions with regard to any of those enforcement cases, but just to note that we have had considerable enforcement activity over the last 12 months. This is as close to year end as we can, obviously year end being tomorrow. And just to note that we have been using some of the new enforcement powers that the Welsh Government have introduced in respect of temporary stop notices and enforcement warning notices. These are very useful tools, and you can see that we've used one for Llanech Vineyard, which is subject of the only enforcement report in this committee. And the enforcement warning notices have also been very useful in focusing people's minds on the need to apply for planning permission for an authorised development.
Thank you. Councillor Parker.
Before I withdraw, is there any update on the hangars A and B at Landau with the fire? Because that's actually caused major problems. That's on page 29.
Yes, the appeal relates to, well, there are two appeals, one of which is the refusal of planning permission, the other relates to the enforcement notice that we've issued, and they are being dealt with as a joint appeal. It's still being scheduled to be heard by way of a public inquiry starting later on in April. However, obviously, we're all aware that one of the two hangars which this use relies on has now been completely devastated by the fire on the site. The building has gone. NRW, who have granted a permit for the site, have required the owners to remove all the waste that was in that building and that was subject to the fire. And they initially suspended the permit for the whole of the site, but have now introduced a partial suspension, meaning that the owners of the site can carry on with their clean recycling sorting. So that's paper, cardboard and clean plastics, but they can't sort any other waste material on the site, including the black bag waste that was in the building that was destroyed. We have been approached now by the appellant in the light of the fire, with the view to asking that the appeal be put in abeyance pending the submission of a planning application that they're hoping to submit just to use the site for the clean recycling sorting. And I know obviously a lot of the issues on the site result from the black band waste and the odours and flies and pests that result from that. So it may be a more friendly, if you like, operator adjacent to the caravan park and the racetrack if it's just the clean recycling that's sorted at the site. But obviously we can't prejudge any application, and the application hasn't been submitted yet. So if an application is submitted, it's likely that we will agree to the abeyance period, but that is only on the basis that the operator it will be an informal arrangement that we could enforce with a stop notice, but only on the basis that they operate to restricted operating hours and that they limit the noise that's generated from the site, etc. So it's a work in progress, but it looks like we may come out with a resolution that hopefully is agreeable to all parties.
Fine, thank you for that. Are we monitoring it or in Natural Resources Wales? Because I actually have followed a few of their lorries in, and I have a suspicion that it's just not all cardboard.
Their partially suspended permit isn't just for cardboard and paper. It's also for the recycling, you know, like plastic, you know, the milk bottles and things like that. And that can be accepted at the site. Although the planning application that was subject to the appeal only allowed or only proposed the sorting of cardboard and paper in that remaining hangar. So the introduction of the recyclable waste to that building is something we'd have to consider, but NRW have allowed them to do that. I think NRW are on the ball in terms of how they monitor the site now, and they're obviously investigating their own possible, you know, the criminal activity that may have resulted from whatever has happened on the site. They, you know, they're in the process of doing that investigation, breaches of the permit, etc. But they, you know, they're on the ball as far as monitoring the site is concerned.
Okay, that's the end of the report. Nobody else wants to ask anything. Okay, fine. We now move on to the enforcement action 2, which is the land and buildings at Lanner Vineyard at Hensel, which you can find on page 35. And I'll ask Justina to go through the report, and then we'll consider the recommendations. Thank you, Justina.
Thank you. As you note from the update report, we've served a temporary stop notice in respect of unauthorised development at the site consisting of a new accommodation block. If you have a look at the location plan on page 36, you can see there the new accommodation block is to the east of the site. It's on land that it was formerly occupied by some of the vines, and those have now been removed and the development is commenced. We have resolved to grant permission for a new accommodation block there, but the elevations of the building that we've resolved to approve are provided later in the report. And as you can see, they're on page 44. It's appears to be a more organic scheme that has the same character and appearance as the existing buildings on the site, the original farmhouse and the accommodation block at the back of the farmhouse. Whereas what they're building on site is the scheme on page 45, or what they've advised us that they're building, which is a scheme that has only just been submitted to us. It's not a valid application, and it's one that we have serious concerns about, particularly as it's a very similar development to the one that was originally submitted in the 2013 scheme. It's one that we negotiated with them to get the amendments you can now see on page 44. So the temporary stop notice was issued because they were cracking on with the development. We had serious concerns about the development that they're building on site, and we are of the view, without prejudging the plan application, that it's one that we would unlikely to give a favourable recommendation to. which prompted the service of the temporary stop notice. Now, we've been advised by the developers that, or we get the impression from the developers that they intend to crack on with the development, and that has prompted the urgent, what I would consider to be urgent service of this enforcement notice and the stop notice, the permanent stop notice that we're seeking to issue with this report as well. And ordinarily you would, with any unauthorised development, if the developer commences with the development, it's at their own risk. But what we are mindful of is the fact that in the past there has been other unauthorised development at the site which has been, some of which has been retrospectively regularised, but you know, there is a impression that the developers you know, carry on with what they want and then seek to resolve it retrospectively. And because we have such serious concerns about the scale of the development that they're building, its character, its appearance, and the fact that it's we think it will dominate this site, we think it's expedient in this instance not only to issue an enforcement notice but also to issue the stop notice to stop any further development on site until the planning matters are resolved by way of either planning applications, which we will negotiate on, or possibly an appeal.
Okay. Any member? Sorry,
Chair. There is one other matter that's covered in the enforcement report, and that's a building that's referred to as the well, I've referred to as the existing events venue, and I think they refer to as the summer room or secret garden room. That again is an authorised development for which a planning application was submitted retrospectively. That also has been resolved to approve, but they haven't signed their Section 106 agreement, which relates to things like sustainable transport and public art, and that's been left unresolved for a while now, and we're concerned that that may become immune from enforcement action, which will stop us getting any Section 106 obligations on it and addressing the drainage issues that may or may not be on the site. So we're also seeking authorisation to protect our position, issue an enforcement notice to stop that development becoming immune from enforcement action, so that the developers are, I suppose, forced into a position where they will need to sign their 106 agreement or come up with some other alternative.
So those recommendations are found on page 50. I believe there are 3 of them. I'll call Nick in. Are those the ones you're asking the committee to determine?
Sorry, yes, Chair.
Yeah, thank you. Okay, Councillor Hodges.
So, thank you, Chairman. The whole idea of having a vineyard in the Vale of Glamorgan was always very, very exciting, and something that we as a council have helped publicise in the past. And then I hear that this new guest accommodation block that they're, like you say, getting on with no matter what, has been put in place of some of the vines there. I think they're getting out of that business altogether, and it's becoming what it is, which is a very different business to what we've previously agreed on all sorts of things. So, Chairman, I've got no hesitation in moving all the recommendations.
Okay. Any other member? John.
Yes, Chair. I mean, it's awful. I mean, I think this is a real challenge to public planning and regulation and all of that. I think the developer is sending a message to the planning system, and it's a 2-word message, and I really think we do have to take the action that's in the recommendations.
Yeah, it's a shame because it's in a nice location. It brings in jobs and prosperity to the Vale, but you have to accord with the planning system. Yeah, and there are rules that we all have to stick to, and unfortunately it's going to be costly for them. What the recommendation is asking for is that Head of Legal Services be authorised to issue an enforcement notice under Section 172 of the Town and Country Planning Act. the cessation of all works on the site to construct the guest accommodation building subject to of this report, the removal of unauthorised guest accommodation building and event venue building, including the slab and all associated materials from the land in their entirety, and restore the land to its former condition prior to the commencement of the unauthorised works. 2. That the head of legal services be authorised to issue a stop notice under section 183 of the Town and Country Planning Act as amended to require the cessation of all works on site to construct the guest accommodation building subject to this report, and then 3, in the event of non-compliance with those notices, authorisation is also sought to take such legal proceedings as may be required.
Can I ask, was it Val the second?
Yeah, we didn't get who seconded
Was
Nick.
it you?
It was Bronwyn. You want to ask a question before we move to the vote?
Thank you, Chair. Just looking at page 47 about the stop notice, which is temporary stop notice is due to expire tomorrow.
Yeah.
So does that mean this is delivered tomorrow, or you're putting a permanent stop on it as well?
This is a permanent.
We're hoping that we can get the notice authorised, signed, obviously authorised tonight, signed by legal tomorrow, hopefully, and that we can issue the notice tomorrow. The stop notice, you have to give a minimum of 3 days to comply with it, so it won't come in, if it's issued tomorrow, it won't come into effect till Monday. And I think the developer and their agents are more than aware that the notice is coming and the consequences if they do carry on with the development. But if any work carries on this weekend, albeit it'll be unauthorised work, but we won't be able to do it. It won't be in breach of any stop notice, whether permanent or otherwise.
Would it be politic to take it down there tomorrow? And then they have no doubt, even if they...
That's what we would do anyway. We have to, you know, issue notices by hand. That's how we usually issue them, so that we're certain that the correct people get them.
Okay, moved and seconded by Councillor Hodges and Bronwyn Brooks. All those in favour of that course of action? That's unanimous. Thank you for that. Yeah. Okay, we're on to general planning applications now. I've been asked if we could move the Cosmiston Medieval Village, which is subject to late reps, and I know there's a speaker. Move it to the front of the agenda. So it's the first item on the agenda. I've been asked if we could bring that forward. Because Councillor Bob Penrose wants to make an application. Now, I'll hear what he wants to ask, first of all, and then it'll be up to members if they want to do what Bob's asking. So, over to you, Councillor Penrose.
Thank you, Chair. Yes, when I...
Well, no, you don't present it if he's going to ask for a site visit. Yeah. Go on, Bob.
When I originally called this into full committee, it was because of strong resident opinions regarding this matter. And at the time I called it in, I did ask for site visit. The application was then modified, and I think in the subsequent one, not through anybody's fault, it's been omitted, the site. I'd like to call it for a site inspection of the planning committee. That's based on several statements inside the report with regard to overspill car parks which are prone to flooding, visibility display of highways, and I think it can only be served by committee actually going to site meeting and having a look at the actual items.
Right. I mean, though, I myself I'm quite aware of Cosmiston. I was in there during the bank holiday of last year. I wouldn't personally want a site visit, but it's up to other members if they feel that they can deal with this without having a site visit. Over to you, Jonathan Bird.
Although I've been there myself, I personally would, I'll second Bob in the request for a site visit. I would like to have a look and see what the issues first hand are, please. So I'll second.
Okay. So, he's asked for a site visit. Are members happy to give a site visit?
Yeah, it's all right.
Okay. Right, okay then. Site
Hang on.
visit it is.
Is it because no one over there seemed to say yes or no?
I think the general consensus is yes.
Yeah?
So, yeah. Okay, so it's back to the top of the planning list. It's, well,
You know,
I don't think... does anybody want to vote on it? I haven't seen anybody object to the site visit. Yeah, it's pointless. Yeah. Okay, fine. So, on page 53, we've got Aberthaw North Quarry, Castle Road, Aberthaw. And I'll ask the planning officer to go through the report.
Thank you, Chair. We haven't got any late reps on this one, so I'll go straight into the report. So members may recall the original application, for those of you that have been around since 2013, for these works. This is now an application to vary a condition of that planning permission in terms of the overall height and restoration levels of the quarry. So the works relate to the storage on and disposal of ash being a waste product from the Aberthaw site, being stored in the quarry, which is shown on the plan up on the screen, the site edged red being the area where the fill is stored. The works proposed are to increase the capacity of that storage area by approximately 1 million tonnes of capacity, which is found to be necessary from the works at the Aberthaw plant. Probably the easiest way of assessing the impact of that is to consider the heights. This plan shows some sections. Hopefully you can see the lines of the sections, and this plan, which hopefully is a bit clearer on the screen than it is in the actual committee report on page 55, which demonstrates the increase in levels across the site compared to what was previously granted under the original consent. As the report outlines, the increase in the level of filling is spread across that area, up to an increase of a maximum of 6 metres at any one point, but across the overall site it's approximately 48 metres, which is 1 metre higher than the existing level of the previous approval. The report also goes through a vast number of conditions that require amending or changing as a result of this change, in reference to various documents and associated matters, which I won't go through in any detail because it's all set out in the report and is pretty much supplemental to the main change, which is obviously the levels. The report goes through in some detail what the landscape and visual impact of that is proposed to be. There have been objections from neighbours in the area, and those are set out in the report and responded to. In terms of the residential impact, the main impact being the extension of the time that is associated with this additional fill, and all the associated noise, works, potential dust creation and traffic movements associated with that increased capacity, and therefore increased length of time of this operation being carried on. The report does come to the conclusion that that is an acceptable impact in terms of the overall impact of the development on residential amenity. The application is recommended for approval.
Okay, I think we've got a speaker against Adam Riley, Councillor Adam Riley. If you want to come over and take your seat. You have 3 minutes which to address the committee. Take your time and go when you're ready.
Thank you, Chair. I'm grateful for the opportunity to address the committee on this application. I'm a resident of East Aberthaw. I have been for 13 years, and throughout that 13 years we've lived with the black dust that comes off wherever they've been disposing of the ash throughout that time. Now, the dust itself, PFA dust or fly ash, it isn't classified as hazardous waste under European law, but that doesn't mean that it isn't harmful. PFA contains trace elements from the coal that can't be burned, and these will include mercury and cadmium, and they'll also be in concentration due to the fact that they're the bits that are left after the burning. The dust mitigation measures from the environmental statement sound impressive, but they obviously don't work as well as they should, and the evidence of that is all around the area where I live in. You can see it on my windowsill, you can see it on my car. We have this black dust all over Aberthaw, Fonmon and Roos. We inhale this dust, it isn't going to be good for us. The background to the application is that RWE's projections for filling the quarry are based on 2015 figures for ash disposal, but the ash produced is likely to be much lower than that going forward. This application was submitted around April 2016, and that was at pretty much exactly the same time that RWE announced that from April 2017, i.e. tomorrow, it would only generate when it was needed, possibly through winter months only. The application says that at current rates of generation, they'll run out of capacity by the end of this year, but that's based on 2015 rates of generation. They've had shutdowns through 2016 and 2017, and onwards it is expected to be much lower surely. In 2015 they sent 376,000 tonnes to disposal. This application would create extra capacity over 1.1 million tonnes. That's 3 years capacity based on 2015 figures. If they're only generating on a few months of the year, it's going to take far longer to fill the current capacity than RWE is projecting. Phase 4, they say, is unlikely to be deliverable before 2020 as there is no available lining material. Why is there no lining material? This is a naturally occurring substance. Presumably phases 1 to 3 are lined with suitable material. And the application says that phases 1 to 3 will be filled to the new capacity limits under this application by 2020 when phase 4 starts. What guarantee is there that this lining material will be available in 2020? What happens if it isn't? Do they then apply to go even higher?
Thank you, Councillor Riley. The planning officer is entitled now to come back and pick up any points that you've raised. If you want to come back. Okay.
Thank you, Chair. Firstly, in terms of the need for the development and the likely use of the existing power station and the requirement for this increased capacity, whilst obviously that was the purpose of making the planning application, it's not necessarily something for us to consider in terms of the acceptability of this development. They obviously felt that it would be necessary. You know, they could close the operation tomorrow presumably and this wouldn't be necessary, but it's not really for us to consider whether or not the planning application is acceptable on the grounds of whether or not it's needed. In terms of the dust mitigation, obviously it has been set out in the environmental statement. Those matters are controlled. They are also controlled by NRW and the licensing and permitting arrangements that the facility has. And again, I would reiterate that this is not about the principle of this development, which has already been accepted. It's about whether or not the increase of this capacity has any additional impacts which are considered to be unacceptable. On that basis, I don't think it would be appropriate to be refusing this application on the grounds of the principles of those sorts of impacts which have already been assessed and considered to be acceptable under the original scheme.
Okay. I look to the other local member.
Thank you, Chairman. The history behind this is interesting because for many years the power station deposited its surplus ash in a very large mound that was granted permission many years ago, and which was the actual bane of the local community of East Aberthaw. Not least because despite efforts to grass it and stabilise it. For many years the power station were working on that, and so forever it was breaking down, and ash was a significant problem. And to some extent the fact that it's now being tipped in the quarry means that mound is no longer rising, and that's tied down with a planning application for the use of tipping in the quarry. So there is a consequence, a positive consequence of that action. So I remember when we first wanted to see this tipped, although there were local concerns, we did see it as a positive way forward. I can see that the detail of information in the report, it's all been thought about. The principle has already been decided. It's a question of amending some of the original conditions. But my big fear is that it is true that I'm receiving complaints about the dust levels. I think Councillor Riley is speaking specifically about perhaps East Aberthaw and Ruth, but I know that in Farmon, people living in that village are suffering from this, and to some extent the fly ash depositing area is close to them. So I do have concerns about this, and whilst I could see the planning principle, maybe one where we should approve, I'm going to seek assurances really that the methodology used for controlling dust at the moment I don't think is as effective as it could be. And I noticed on page 66 the last but one paragraph makes reference to more detailed management procedures will be updated where necessary to reflect the changes in levels. But again, I think we have to do our best to defend the interests of the local population who are going to be going to be adversely affected by an increase in levels. So I think that rather than continue the methodology used to protect the local area from dust, which seems not to be totally successful, that we need something better to actually give that kind of reassurance to the people that they're not actually going to get more dust because it's going to be higher, and therefore as in profile it may well be carried by the wind more likely to. So these things I think are of great concern to the local people and certainly to myself. And I think on that basis, Chairman, I think that I would actually move that we I'm tempted to move refusal to this, Chairman, because I'm not against it in principle, but I am against it in practice, because clearly the local people are being bedeviled by dust. And if that's not resolved, approving this, in my eye, would actually be tantamount to accepting that people will be having dust on their cars, on their windowsills, in their gardens, in the hedgerows, and to be honest, I can't do that. So unless there are sort of adequate assurances, I will actually be moving to refuse this, Chairman.
Okay. Do you want to come back on that first, Vicky?
Thank you, Chair. I would guard against a refusal of that nature, not least because NRW and the Environmental Health Officer have not objected, who would be the technical experts in that matter. So you'd be going against their advice. They're satisfied with what's been suggested in terms of dust mitigation and the environmental strategy. So clearly, they're our technical experts. They are who we should listen to about these matters. If there are problems existing with the existing dust suppression methods, then I would suggest the correct body for resolving that are NRW, and we can certainly take that matter up with them and with our environmental health colleagues and see what can be done in terms of ensuring that the existing practice and this proposal, if it is approved, are carried out as they should be to minimise the amount of dust coming from the site and so on. But I wouldn't say that that's a reason to be refusing this application, because the adequate controls are there as recommended in this report to ensure that those matters are covered off properly.
I think Maureen Kelly-Owen had her hand up first.
Only because I went to the site meeting many years
turn your microphone on, please.
Beg your pardon. Only because I was at the SAT meeting many years ago when we were assured of how splendid it was all going to be, and the local people shouldn't worry. We're in a position where the local people have every reason to worry, and I want to support what Jeff is saying.
Okay, thank you.
Because if it's in the air, it's on the covers of prams. You know, it's there, it's happening, it's not imagination. They've seen it with their own eyes.
Okay. Councillor Jonathan Bird.
Chair, if we were minded to approve this, could we condition that an improved dust suppression system is put in place and or suggested, you know, with talks with NRW? Because clearly, I hear what Vicky's saying, but people are not complaining for the hell of it. They are seeing dust at their homes, and it is an issue. It may not be a planning issue, but there must be something we can do, maybe within the conditions or something like that, you know, grant them a permission, but subject to improved dust suppression levels, because the current levels are not working. And they are putting people's lives and health at risk. Unless we can do that, I feel quite strongly that I can't support this unless we can condition some form of improved dust suppression.
Well, we'll ask the planning officer to come back on that. Was your point similar, Councillor Parker?
No, actually what I was going to add to it was that I thoroughly agree with all of that. And I think whatever condition it is, I think that the details of that condition and the understanding of how that the measures are going to work should be brought back to the committee for consideration and possible discussion.
Chris wants to come in.
Sorry? Okay, Chris.
And John.
Thank you, Chair. I must admit I was a bit apprehensive when I asked for this to come to committee, but I'm now delighted that I have. We've heard first-class evidence from the two local councillors and comments from elsewhere. And basically, the existing regime is not working, is it? And we've heard about this dust on windowsills and cars and the like. It's also in people's lungs, I suspect. It can't not be, can it? So I don't see, in all conscience, how this can proceed today. We're told we shouldn't reject it, but should we approve it with the clear message that we're getting that it's a health hazard to people? And I don't see how we can say, well, let's tweak the regime a little bit and it'll improve things. I don't think that's credible, and I don't see how we can approve this tonight. Thank you, Chair.
I have to say, from my own point of view, I've not seen any evidence, apart from what the two members have just told you about dust. I've not seen any evidence in this report that leads me to believe that it's a health hazard. I'll ask the officer to come back first of all, because there's been some mention of health. So,
Chair, can I just come in? I've had some dealings with NRW lately on their permitting system, and it's quite a different approach to the planning system. Obviously, planning, we consider all the impacts up front, we impose conditions, and that's our only opportunity to do that. Whereas the permitting system is an organic system that develops as issues arise. So the owners of the site, or the developers, are granted the permit. If issues arise, and those issues can consider all types of pollution, including dust, if issues arise, then NRW step in, and it's the developer's responsibility to address those issues, come up with mitigation measures, revise mitigation measures if needed, to impose those mitigation measures, and then to assess the impact of those mitigation measures, and if they're not sufficient, then NRW step in again. And so the way that the permitting system works is that if issues arise, they're dealt with as and when, and it's not just a one-off, it's continually addressed. And obviously, they're the correct authority when dealing with concerns about pollution and impact on human health. They're the correct authority to deal with those issues. They have the expertise. And if you were to impose any further restrictions on mitigation measures, it would only be NRW that we would turn to in order to ratify those. And as I've said, it would be only a one-off opportunity, whereas the correct regime for those issues to be considered is under the permitting system. I just wanted to add that in view of my recent experiences with NRW and the way that their system works.
Okay. I think Nick Hodges wanted to speak. Yeah.
Thank you, Chairman. It seems to me that NRW is going to be very, very busy in the Vale over the next few years. It must be a growth industry. Can I say that if what the local members are telling me there's dust about, and I've seen it as well, then that shows that the present permit with NRW is failing. And now we're being asked to double the amount that's going to go in, that it's going to go higher and bigger. And I'm sorry, I can't agree to that, because mitigation on a permit by NRW after the event is the very, very thing that I'm concerned about in this town with our incinerator, that it comes after the event. I'm sorry, I want, if I'm to allow, as a member of this planning committee, anything that is possibly injurious to the health of anyone, I want it tied down rock solid before we even go anywhere near NRW. Now, I can't allow this, Chairman. I will be voting against.
Where have you seen that
I've
it's
seen ash
dangerous to people's health?
I've seen ash, Chairman, and ash is breathable in. It's particulate waste.
And where are these people who breathed it in and they're ill because of it? Where's your evidence? There is no evidence.
Ask the local members.
Well,
where's your evidence it's not, Chairman?
John?
Mr. Chair, I wanted to ask the planning officer a question about length of time of a planning application, which Vicky touched on earlier. Most of our planning applications and developments, you're putting a building there and it is for a long term, but this kind of development is one of a smaller number where they are envisaged as being of a limited time frame, and it's kind of, there's an assumption in there that actually the activity isn't that desirable in itself, and that's why we cover it over afterwards and we, grass it and landscape it, etc. Is there nothing within the planning policy system which considers that situation, that a planning application that is appropriate and to be approved after a period of time might actually get to the point where actually no longer is it appropriate? So that was the question I wanted to ask. I just wanted to comment on the points about trying to strengthen the conditions if we approved it, so that we try and reduce the nuisance from the dust. And there is a good reason for doing that, is that if we make that formal decision, it does strengthen officers' hand in their discussions with NRW to try and control this better. But what it might come down to is that actually our pollution control regulations in this country are not adequate. And I get the impression that the direction of travel is not towards better control of pollution at the moment. But, it's a concern if there is dust in the air. And I do recognise that we would probably lose this on appeal, just because that's the way the system works. So I would rather approve it with strengthened conditions along the lines that Councillor Bird was talking about, and take up the cudgels with NRW to say that, clearly it is not working adequately.
Thank you. Any other member? Councillor Jeff.
Thank you, Chairman. I'm going to say I appreciate the point that's made by officers that the monitoring and licensing authority is in NRW. But when we originally granted planning permission, we also granted approval for the way in which the ash was going to be dealt with and the way it was going to be managed, and that included the use of water. And now I'm being told, well, actually you've got to trust in the National Resources Wales to carry on their responsible tasks and monitoring. But my fear is that unless we actually introduce more robust ways of dealing with that dust, then we will have less ability to interact with the applicants, and we will be granting permission and walking away from it, and trusting in the National Resources will. And I'm really worried about that, because it's quite clearly not working now. I myself have reported instances to the power station and asked them to come out and take samples. It's not always conclusive. So I think, Chairman, I think I'm going to be more satisfied and feel safer in falling on the side of the people who have to deal with this, and I'm going to move refusal, Chairman.
Okay. Peter King.
Well, I'll second it if we're not going to improve the condition.
Okay.
I think there's some good arguments being put forward here about pollution, but we don't seem to have any evidence.
No.
And I hesitate to sort of defer anything. That seems to be all I ever move. But I am wondering whether we should actually defer to allow people time, our officers, to speak with perhaps our own environmental health people, to talk with the national people, and maybe the people who've made evidence tonight to look for their own evidence, because I would rather make a decision based on evidence than gut feeling. The only comment I would add is that I'm frequently told we've got to make all sorts of allowances for wildlife and dormice and all sorts of other things, but here it seems to me more to do with human health, and that doesn't seem to be getting the same level of study that we would have to undertake if it was some obscure species of plant. So I'm actually going to move deferral to allow that gathering of evidence.
John Drysdale.
I wanted to propose a condition along the lines some of us have been talking about, and it would be parallel to the situation where we have a planning application where, for example, we put a condition in about a drainage plan or an environmental management plan, and we do it post the approval to say, well, we'll need more detail on that. I think we could impose a condition that says, subject to a revised satisfactory management plan to reduce dust in conjunction with Natural Resources Wales and the applicant, and with reference to the local community.
Okay, and I've got Gwyn Roberts.
Thank you, Chair. Can I second Councillor King's motion and perhaps ask the others who've removed refusal to withdraw that at that time being? The fact is, if we refuse this now, we will be a bit like Pontius Pilate washing our hands of it, because it goes to appeal and it then goes completely out of our control. I think, to be honest, clearly there are concerns about the effect on human health. As you've pointed out, we haven't got that evidence. I think what we need to do is to actually give ourselves enough time to see if there is evidence, and if that evidence comes, then make our decision based on the facts as we by then have received them, because we haven't had it. And we have some people in this room swearing that there is a huge effect on human health, and that we have no evidence saying that it does. I notice the report has a number of conditions relating to rare birds, how it may protect them, including one which seems like a reasonable distance away. But I think it would be sensible, rather than just say no, wash our hands of it, then it's quite possible it'll go to appeal and we will lose on appeal. It seems to me that we should try to keep control of it by having a deferment in order to gain better evidence to reassure us, both in terms of what's happening now and what other conditions can be applied that may at least go towards partly satisfying the residents. So I second Peter's motion.
He's seconding Peter King's motion for deferment. Shall we ask the planning officer to come back and after you've heard all these speakers?
Thank you, Chair. Sorry, I've made a couple of notes, but I think the discussion seems to have moved on and moved on. But
yeah.
Just to come back on the point that Councillor Drysdale raised about the length of time that an operation like this goes on for, and whether we not consider that at the time of determining an application. And this was not granted for a temporary time period. It wasn't the type of operation. There have been others where we do specifically grant them for a limited time. It wasn't. Having said that, the operation by its nature, you expect there to be an end point at some point, and that the site gets restored. Similarly, this operation is just to increase that capacity. There isn't an end date on it, but there's a presumption that it will end at some point. But I think in assessing both the first application in terms of the principle and this application, there has to be an acceptance that what you're granting permission for could go on for quite some years, depending on how long it takes them to use up that capacity. So you are assessing that impact over a number of years. Officers have assessed that and considered that the application is acceptable on that basis. It's up to members whether or not you agree with that. So that was just to cover that issue. In terms of, you know, the comments that have been made, I've already, you know, said that I don't think it's a sensible decision to refuse the application contrary to the technical officers and NRW and environmental health officers' advice, who have not objected to this application. So for obvious reasons, I'm not recommending that you do that. In terms of adding a condition, by all means we could do that. It would to a certain extent be doubling up on what NRW's roles and responsibilities are, and obviously they are the correct authority in terms of ensuring that these matters are covered off. But having said that, you know, I would be happy to add something that would at least give a level of input from us as local planning authority in terms of working with NRW to ensure that the dust suppression measures are satisfactory and overcome, you know, what appears to be problems that have been experienced. So that's all I would say.
Okay, Councillor Bird.
Thank you, Chair. I think there seems to be a little misunderstanding or misconception as well. As I understand it, the dust is not necessarily harmful, and don't go poo-pooing me, you hear what I've got to say, to people's health. But what it is, it's detrimental to their well-being and their life. You know, if you've got dust on your windowsills, your windows, your clothes, your car, it's coming in your house, it may not affect your health in the long term. We don't know. It's classed as an inert dust. And this is where NRW are coming from. But it is a blight on people's houses and the way they live. And this is the problem. NRW are not enforcing this strongly enough because it's not a toxic dust. Now, if we can double up with a strong condition, that encourages NRW to perhaps look at the dust suppression in a little bit. You know, we're saying we've got these concerns. It may not be toxic, but we don't see that these people should have their houses and lives blighted. I'm more than happy to do that. So I'm going to run and go with John's suggestion that we do this now and we condition it as strongly as we can.
Have you got a form of words, John? Hold on a second, I've got one or two speakers. You were talking about a strong condition though. You must have something in mind.
Yes.
Would you? Yeah,
You,
the
did you
planning
take
officer's
notes?
going to...
Yeah.
Right.
Yeah, I don't particularly want to give you a precise wording of a condition off the cuff. If you can trust me, I understand the message that you want a more robust dust mitigation strategy than what's currently being operated at the site, and that we can request those details to be submitted, and we can obviously discuss those with environmental health officers and NRW to make sure that it is a robustly worded condition.
John?
Yeah, I mean, in relation, I'm happy to have Vicky do that, and I just want to suggest that there is reference within it, not just to the suppression of dust for the purposes of pollution, which to NRW has a very specific technical meaning, but to suppression of dust because of the impact on the quality of life and nuisance to the local community, which is a different matter. And we do that quite often in our planning applications with conditions about noise nuisance and dust nuisance and mud on roads. We can do that.
Councillor Parker?
Yeah, I mean, I think the answer is actually on page 65, where it says Natural Resources Wales have noted that an environmental permit variation may be required. Now, what we want to do is say that if it is required, then we want to see sight of that requirement. It also says that the bund height might have to be increased. Well, again, those are two things that we would want to be satisfied adequately protected your condition.
Okay. Councillor Powell?
Thank you, Chair. I think that I heard mention to the original application that had conditions with regards to dust suppression by the use of water. And if I did hear that, then the obvious question is, because it's down to NRW to monitor that, how do we know that this is actually going on, or that 5 years ago all the nozzles on the sprays got blocked and they've never been cleaned? Have we got assurances that this dust suppression that we originally conditioned is actually up and running and working efficiently? Because from the anecdotal evidence that we've heard this evening, that clearly isn't the case.
That would be for enforcement.
My understanding of the permitting system with NRW is that they pay an annual fee for the permit, and that fee covers monitoring by the NRW officers. So unlike planning enforcement, where we're not paid, the council aren't paid to enforce something, it's all in the planning fee, I suppose. NRW are paid an annual permit, as far as I understand, and that allows them this monitoring. Now, depending on the type of permit and the activity that's covered by the permit, that depends on how regular the visits are. So they would be checking that the mitigation measures that they require by their permit are operating at the site. So it isn't the case that they're put in place and they wait for an issue to arise before they step in. They do monitor the sites, and my understanding is that they check all the mitigation measures for all the pollution issues that relate to the site, and then they provide a report, and if further measures are needed, then that's recommended and required of the developer.
Yeah.
Thank you, Chair. Can I just say, I can't remember reading in this report anything from NRW that has actually said when they last monitored and that the dust suppression, I mean, I would have thought that that was a very, very important piece of information that NRW should have provided, so that we are making decisions from a position of knowledge. And I would like to know how often NRW are monitoring this, when they last monitored it, and was everything working to suppress the dust?
Well, for me, this has only been brought to me by the local councillors. Has it been brought before the NRW before? Are they aware that dust is floating around in the atmosphere and people are white? These things, yeah, but we're considering a planning application. And what has been brought to you are concerns about local people. Have those concerns gone to the Environment Health Officer? Because the Environmental Health Officer in this report has no concerns, because he hasn't been told about them. Councillor Hodges.
Thank you, Chairman. I'm going to agree a lot with what Tony's just said, and I had it written down that whilst I said that I would be opposing the increase here, I would be prepared to defer if we actually call NRW to this committee and bring their monitoring evidence with them for the last few years. Because if they are monitoring it, let's find out what the facts are. And I would go further. Surely, for a committee like planning, where we actually look and have annual reports still on the state of our quarries, are they being used, what state they're in and everything like that. Surely we should be calling NRW annually into the Environment and Regeneration Scrutiny Committee to report on this and all other things that they monitor supposedly on our behalf, so that we can we can question them. Now, if we're prepared just to grant them an extension to this licence that's bigger with a few variations of conditions without knowing what the present situation is, and I've heard about water suppression, is it working or not? Well, they should know, because they're supposed to be monitoring it and looking after the permit. So let's get them in and let's ask them. And that's their job.
Yeah, Cam.
I don't really want to speak again, but a point of clarification, you mentioned environmental health. I have reported to environmental health about the dust on many occasions. They have drawn my attention to Welsh Government guidance that says where two organisations have responsibility for monitoring things like dust and operations, that one should be considered as taking the lead and superseding the other. And in this case, because the power station and these other working places are controlled by National Resources Wales, environmental health have nothing more to do with them. Complaints now have to go to National Resources Wales.
Thank you for that point of clarification. Planning Officer. Hearing what you've heard.
I don't think I've got anything else to say.
No, okay. Well, are we going to defer, or are we going to... Yeah, we've got a motion to refuse, haven't we? So, well, shall we go through that first of all? Those in favour of refusal? Yeah, yeah. Those in favour of refusal, please show. Yeah. Yeah. Okay. Thank you.
Just seems a little bit out of running order, because if we just take the refusal or agree, then we're not given the opportunity to defer. So should we not take the deferral as an amendment so that we can take that first?
Hold on, I'll just listen to what the legal officer says. The legal officer, Anthony, has said that I've done it right. It is, I've asked for, because a motion was put, it's been seconded for a refusal. That is, we're going to now, those against, so if you allow me to do that, and then I'll explain what we'll do next. So those against that refusal, please show.
I'm worried that it's going to go further.
We're not doing that, Margaret. Okay, that's clearly carried, so that refusal is not granted. Then we had a motion for deferral. So I'm going to take that deferral first, and then John came in with another one where he would accept the proposal, provided Vicky drew up some other conditions. Yeah. No, I don't see the point of doing that, but I've never had a... yeah, would you come back?
I can invite NRW to attend. I obviously can't impose
and if
or
they
force
don't
them
come,
to come. So
there's nothing you can do about it. Yeah. Right, okay then. So we've had a motion to defer. Those in favour of a deferral, please show. Those against? And I abstained.
And so did Jeff.
Oh, and Jeff did as well. No. Did you abstain as well?
No.
Yeah. Okay.
Sorry, Fred. Can I just point out that on page 66, the existing planning permission includes a condition which requires the implementation of dust control measures, which are formalised through management procedures, blah, blah, blah. We can take action now if people are concerned and Justina can, because they're in breach of a condition if the dust is causing a problem, and that could be a possible, it's a thin way, but it is a way that might achieve it.
Is that right?
We can certainly look at the condition and the dust mitigation measures that were approved on the original permission. As I said earlier, though, we would take advice from NRW and maybe even our own environmental health officers. I appreciate Councillor James suggested that with regards to pollution, they would defer to NRW, but they can still give us advice on planning conditions. So we can certainly do that and open it up as an enforcement investigation.
The only issue I've got with all of this, Justina, is that no evidence has been put before this committee to say that that dust comes from the operation of that ash tip. That dust can come out of the chimney stack at Aberthorpe. And I know that ash does fall on motor vehicles here in Barry. So I'm not convinced that that is the right course of action, but it's been deferred, and perhaps the officers now go away and look at the whole situation and come back with a further report.
All I was going to say is that all I can look at is whether they're complying with the mitigation measures that were approved. If those mitigation measures aren't found to be sufficient, then that's not something I can, we can't review the condition.
Okay, Councillor Powell.
Thank you. It's really with what Justina has said about she can only check whether there is compliance with this condition. But one of the ways that we can check if there's compliance is by mobilising our environmental health section so that they could provide proper test results and evidence for Justina to make a decision on whether they are complying, and also on your concerns as to whether the dust is coming from there or not. So I'm just wondering if that could be taken on board.
I have to say that the other worry I have is that we're turning this planning committee into an investigating committee, and that is not what our role is. We're here to determine planning applications. But what is coming out from members in here is all to do with what their fears are, and I just worry about where you're going with it. But never mind, we'll move on. That has been deferred. We're on to page 84, Pennyland Road, Aberthin. There are some late reps that are tabled before you, and I know that it was subject to a site visit earlier today. So I'll ask the officer to go through the report. Thank you, Victoria.
Thank you, Chair. Just to draw your attention to the late representations, we've had a letter from the applicant responding to some of the concerns that have been raised by neighbours, which are set out in the officer's report, and also a further letter of objection from a local resident. Again, the issues raised are covered in the report. Okay, so the application is for a site on the edge of Aberthin, outside the settlement of Aberthin, but adjoining the settlement, and within the Upper Thor Valley Special Landscape Area. You can see the site on the plan on the current screen. It's obviously the small parcel in red. It's in between two existing residential properties known as Tinnatile and Pennebryn, Pennebryn being the listed building to the south of the application site. The proposal is for a two-storey detached 3-bedroom house with access directly off the Pennyland Road. The scheme follows the refusal of a previous scheme, which is outlined in the report, and this scheme itself has been amended. It's now recommended for approval. Just going through the main issues briefly, we have had comments and concerns from Cowbridge Town Council and from local residents. One of the issues of concern has been parking and highways and visibility, but those matters have been covered in the report and we're satisfied with the proposals. Also issues like the visual impact of the development, its impact on neighbouring properties and so on, which have also all been addressed in the report. Those of you that were on site today obviously saw that the site has quite difficult levels in terms of being developed, so there will be quite a lot of cut involved in the existing site, which slopes quite steeply up from the existing road in order to accommodate the new dwelling. The proposed street scene that's shown on the screen at the moment demonstrates the difference in levels between the properties either side of the application site, meaning that the proposed dwelling will be taller than its neighbouring property at Tinner Tile, but it will be lower, roughly in the middle between the two ridge heights of the properties on either side. As I alluded to, the application is recommended for approval. The only other issue I'd just draw your attention to is the council's requirement for affordable housing. Again, in this case, these matters have been considered in some detail in terms of the viability of the site, which demonstrates that it's not affordable for it to be, for any provision to be made for affordable housing or a cash contribution. So in this case, there is no Section 106 agreement securing any element of affordable housing. I think that's it, Chair.
Okay, Councillor Parker, you called it into committee.
Yes, thank you, Chair, and thank you to the members that came out this morning to have a look. I recognise the officer's recommendation for approval. However, my considerable concern, amply demonstrated this morning by somebody trying to reverse out of the little drive, is that you can't actually get out and in one movement. You reverse out, you then do a sort of a three-point turn to go down the road. But the major concern I have is that there is a sloping drive which will discharge straight onto the highway here, and as the road slopes down to the bottom, you're going to have to catch the surface water at the lower end, and then you're going to have to actually manage to put a drainage system in to a rock, because we're in solid rock there, that will stop any surface water going out onto the highway. Any surface water that goes out onto this highway is extremely dangerous. We've had problems with flooding off the fields and things, and if it freezes up, we have major problems. So whatever else happens, there must be an even stronger condition to say that prior to any commencement of work or anything, that a full system to prove that surface water will not discharge onto the highway, and I have serious doubts whether or not that system would work.
Any other member? No? Would you like to come back on that, Victoria?
Just to draw members' attention to condition 3, which is on page 107 of the report, which is pretty much our standard condition, saying that no development shall commence until full details of a scheme for foul and surface water drainage has been submitted to and approved in writing by the local planning authority. And it goes on that it shall be fully implemented prior to beneficial occupation of the site. I think that that satisfactorily covers off the issues that Councillor Parker has raised.
Okay.
Yeah, I'm happy with that. What I was doing was pointing out that I want that thoroughly investigated, not just a simple. It was a flat site; it would be very easy. But surface water, you'll have to put a permeable hard surface on there, which will allow the water to soak through. But the surface water eventually will find its way onto the highway. But I accept Vicky's comment on the on number 3, condition 3. But I just want to make sure that it's fully understood. And if it's possible for the local ward members to have a sight of that, it would be most grateful, but I understand the reasoning why.
I am loath to agree to saying, oh yes, we'll definitely see one. That simply the volume of work that we deal with in terms of discharge and condition, and to recall, this might not come in for another 5 years. So I can't offer you that promise, really. It will go to our drainage engineer, who is obviously the expert in this area, to ensure that that matter is the correct technical information is included before we discharge that condition.
Okay. Officers have made a recommendation of approval. Those in favour of that approval, please show. Have we got a first? Yeah, we haven't had a seconder to it, or a first.
No.
Who's going to move it? I'll move it from the chair. Seconded by John Drysdale. Okay, those in favour of the officer's recommendation, That's unanimous. Abstentions? Councillor Parker. There we are. Thank you very much for that. Moving on to the next one down, which is the Highlands Old Barry Road, Penarth. That's subject to late representations, and I know we do have two speakers who are going to speak against the proposal. It's on page 132, but I'm going to ask the officer to lead us through the report first.
Thank you, Chair. Just to draw members' attention firstly to the late reps, which start on page 11 of the late reps bundle. We've had another objection from a neighbouring property who's objecting to the access being too close to their own. And we have further comments from the Victorian Society, who are maintaining their objection to the loss of the building and recommending refusal on that basis, and that the council include the building on its local list. Okay, in terms of the proposal, the application site is within the settlement boundary of Penarth. It's served off the road called Old Barry Road, which those of you that are familiar with the area is a road that's served off the main link road, being the A4055 between the Mary Harrier and the Barons Court. Excuse using public houses as reference points, but I think everybody knows them. So you'll be familiar with the access onto the A4055, which has been an issue raised and is addressed in the report. The site, as you can see from the site plan on the screen, is a large site, and it currently houses two separate residential properties. The main one being the Highlands, which is a substantial Victorian property, which can be seen from quite significant distances from the site. You can see it from the link road, for example, coming up from Cardiff Bay. So it is quite a prominent building in its own right. There's also a coach house to the back of the site, which is a separate residential unit. So the proposal is to demolish those existing buildings on the site and to build 11 separate dwellings, 8 of which are detached two-storey detached properties, and 3 of which are a terrace of affordable housing units, which you can see in the bottom right hand corner of the site on the plan that's currently on the existing screen. There have been a number of objections to the scheme from various bodies, including the Victorian Society, Penarth Town Council haven't objected to this application, but they do say they have some reservations over the overcrowding and the visibility of the development, and also to some trees that have previously been felled on the site. Sorry, it was the Ancient Monuments Society and the Victorian Society that have objected to the loss of the existing building. In that regard, the existing building is not listed, so it's not statutorily protected, nor is it locally listed as a county treasure. You'll note from the report that the Council's Conservation Officer has obviously considered this application and has suggested that it potentially merits inclusion on the county treasure list. What that doesn't do is provide it the statutory protection that it being a listed building would do. CADU, on the other hand, have looked at it from a sort of spot listing perspective, which is what they would do if they were required to list it, and have said that they don't think it merits that level of statutory protection. So to all intents and purposes, it does not have the protection to prevent the loss of the existing building. The applicants could, irrespective of this planning application, if they wanted to put in an application for prior notification of demolition, they could do that tomorrow, and the council would have to consider that. That is essentially permitted development, and we control the method of demolition. So whilst I note that there have been a number of objections to the loss of the existing building, I think the officer's report explains quite clearly why we don't think it's possible to resist the demolition of the existing house. Other issues, I think I'll just draw on the highway issue, which was raised today on site. We did have a look at the existing junction onto the main busy road there. There have been historic refusals of planning applications along the lines of the impact and the highway safety issues of the junction where Old Barry Road meets the main road. this application was supported by a transport statement which sets out that impact and the impact of the additional 9 units beyond what's already there would not cause a highway safety issue, and our highway officers have agreed with the conclusions of that report, and they point to the changes that have happened since the previous refusals of planning permission, the change in the speed limit along, it's called there the Barry Road, so I'm going to call it the Barry Road, along Barry Road, and also the change to a traffic light junction on the Barons Court, what was the Barons Court roundabout. So in their view, those 2 changes have moved the situation on to a degree where they do not consider there's a highway safety issue in terms of the intensification of the use of the old Barry Road onto Barry Road Junction. Obviously, the officer's report does recommend approval, and just to point out, there are also Section 106 requirements associated with this, which are outlined on page 157. So it's that the 3 units shown as the affordable housing units be provided as affordable housing units on the site in perpetuity, 2 being social rented, 1 being intermediate units, and also that a contribution of £7,650 be paid as a contribution towards existing play facilities at Cogan Leisure Centre, which is the off-site public open space contribution. Okay.
Thank you for that. Well, I've got 2 speakers against. It's Mr. and Mrs. Honeybone. Would you like to come up and take your seats on the top? There are microphones there, and have you decided who's going to speak first? You're going to speak first. Okay, Mrs. Honeybone. In your own time, when you're ready, you can sit down while you speak. Yeah, no, stand up, that's fine. Yeah, press the button, and the clock will start when you've introduced yourself.
Okay, I'm Nadine Honeybone. I live on Gwelder Moor, which is adjacent to Highlands on the map. The border runs parallel along, so we have quite a common border that's quite long. And my husband will go through some of the other objections that we have, but I want to talk about my request for the planning conditions to consider noise and disruption to our family and where we live. Excuse me. And I'll just explain why. We have a son who has severe autism. He has a severe learning disability, and he has a severe sensory processing disorder. Excuse me. We moved to this house for peace and quiet. He is a very, very vulnerable child, and he will be a very, very vulnerable adult when he grows. He's 12 years old now. His mental ability and his developmental ability is of a toddler of 2 years old. He's only recently out of nappies. He has no speech, no verbal communication. He self-harms a lot. He displays very aggressive behaviour. A lot of this comes down to his environment, the way that you and I can process our senses, and for instance, noise, and we can perhaps, put it outside, and we don't take notice of it. For him, everything is on full volume. He melts down with loud noises. He wears earphones like you get on building sites, but he wears them constantly because he cannot stand and cannot process noise. Our home is very quiet and it's very safe. As you know, it's a dead end, so there's not a lot of traffic there, and it's very safe for him. He has no sense of danger whatsoever. He will run whenever the possibility takes him. That's why we chose that place to be a very safe place for him to live in and grow up in. So my urge for the planning group is, if you would consider, when you're making your decision really, on setting some quite strong planning considerations around this noise and disruption that we might then encounter. Also, just to say, we are a dead end. There's obviously needs to be access for taxis and ambulances and stuff. There are 2 vulnerable adults also on Old Barry Road. One is my mother, 83, another one is Esme that lives at the end as well, has regular ambulances. So obviously, that road is very tight when there's a big lorry on it. So, and we would want to be ensured that there is access at all times for school transport and for ambulances and such as well. Again, sorry. Yeah, that's really my point, is if you want to understand a little bit more about autism and how it would affect us and the family and him, then I'm obviously obviously we'd be happy to have be involved in the consultation going forward about that as well.
Thank you. Shall we hear from your husband next? And then if any member wants to ask any points of clarification, would you mind turning your mic off and then... Lovely, thank you.
Thanks, Nadine. My name is Alan Honeyborn. I'm Nadine's husband. I live in Gweldermoor and immediately adjacent to the proposed site. The two areas I'd like to cover in my 3 minutes are, firstly, the unenablingness of this development, and secondly, coupled with the loss of amenity, and secondly, the potential loss of an unique and iconic landmark. Some delegates came today for a site visit. Thank you very much for coming. I hope you were able to see the topography of that particular area, something that's not necessarily able to be projected or communicated on paper. But as you can see, the proposed development would be incredibly intrusive as regards our garden and our property. It would be looking directly into habitable areas, and there would be an enormous and deleterious impact on our own amenity and enjoyment of our house and garden. I'm aware that it's not a conservation area. However, I would consider the development to be markedly incongruous with and exceptionally different from the prevailing character of the area. Now, for many people, this house actually means Penarth. If you're heading towards Penarth, you will see this from everywhere. It is a magnificent house. Let's make no mistake about that. Since the intent to demolish this house was made public, and it's come into the public domain, there has been unanimous opposition to it. And I would like to make that clear to the committee. It's well recognised and it's much loved. Before I forget, one thing I was astonished at was the fact that permission was given to fell trees while bats were roosting on this particular property. As I said, it's unique, it's iconic, and it actually represents the gateway to the Vale. The sign to welcome to the Vale is right underneath this house. I too was astonished that it was not listed, and it's not on the County Treasurer's list. I'm guessing that's more a function of error or omission. The lack of listed status does not necessarily mean that it should be demolished. Likewise, the lack of listed status does not mean that it cannot be saved. And how do we go about doing that? It's very simple. I respectfully invite the Planning Committee to do so. This is a landmark. I respectfully invite you to save this house. I'm in no way, I don't necessarily object to housing development. I would just like to see it done in a more thoughtful fashion. And that's broadly all that I have to say, and I thank the committee for their time.
Thank you very much. Members are allowed to ask any points of clarification on what has been said. If any member wants to ask anything, otherwise I'm going to ask the planning officer to come back on what has been said, particularly over the noise and the building times. We'll address that. Any member? No? Oh yes, Peter King.
Thank you, Chair. I don't necessarily have any issue with the officer's appraisal and assessment and put out in their report. It taken
Are you asking
singularly.
the
Oh, sorry.
Are you asking?
No, I thought they'd sat down. Sorry.
No. Okay, you can come and sit down. Before Councillor King comes in, on what has been said, the officers are entitled to come back and say, okay.
Thank you, Chair. I'd like to thank Mr and Mrs Honeybone for their very heartfelt representations, which I'm sure have moved members and have certainly moved me. I have every sympathy for the issues that you're facing in your personal circumstances, but I have to advise members to the degree to which you can take those into account as material planning considerations. It would not be reasonable of us to refuse an otherwise acceptable development within a settlement boundary on the issue of noise and disturbance for a particularly sensitive end user. If we were talking about, for example, a noisy industrial use, those sort of uses that would be particularly sensitive, then those issues we really could consider in a bit more detail. But what is being proposed is a residential use in a residential area. It is an intensification of the existing use of the site, there's no doubt about that, but I'm afraid that we really shouldn't be taking into account the acute personal circumstances of the occupiers of the neighbouring property in what is otherwise a normal scheme for residential development. So I'm sorry if that is hard to hear, but I feel that I do need to say that. In terms of enabliness of the development itself, those issues have been addressed in the report. They have been assessed in terms of the proposed dwellings being set away from neighbouring properties to comply with our amenity standards SPG. They do that. In terms of overlooking, those issues have been addressed. So I really don't think that this development is going to have an unreasonable impact on the amenity of neighbouring properties. In terms of the felling of the trees, they weren't TPO trees, so those works were carried out without the requirement to need consent. This is not a conservation area. I can't comment on whether or not there were bats roosting in those trees. That clearly is a matter that's outside the scope of this committee. And in terms of the loss of the existing building, I think I've probably already covered that issue, unless members want to ask me any more about that.
We can condition the building of the properties, though, can't we? The hours that they come onto site, the days that they work.
Yes, Chair. Yeah. There is a condition which is number 13,
yes,
which is our standard condition to do with construction environmental management plan, which details things like noise, lighting, dust, and other airborne pollutants, vibration, smoke, etc. during construction, how those will be controlled and mitigated, the requirement for the considerate construction scheme, and also obviously our environmental health colleagues do have powers in respect of noise nuisance. So if the construction was being undertaken during antisocial hours and so on, they do have those powers to control that.
Could we ask for a management plan before the granted permission as one of the conditions?
That is what condition 13 asks for. It's for a management plan.
Oh right, okay then. That's covered that then. Okay, so the local member, Peter King, I think you asked for it to come to committee.
I did, thank you. As I say, I've read the report, I've been to the site, I've listened to the officers' arguments, and I don't really have any particular argument with any one issue in itself, but it's the cumulative effect that I am concerned by. First of all, taking from this morning's site visit, anyone who's seen it, the two-storey building is certainly a fairly magnificent and impressive building, as recognised within the report, and I think it does deserve some greater consideration. It is visible from some distance and from most sides. And yes, there are comments from the Victorian Society and the Ancient Monument Society, and I would draw your attention to those on pages 138, 142, and within the late reps. Regardless of the officers' comments, I still think we need to weigh those up. We are told that it's fallen into some disrepair, and it would be uneconomic for repair. Although there's no structural report been presented, or indeed even commissioned, and what I would say is that, unlike some of the buildings this committee is sometimes asked to look at that are fallen into disrepair, this is still habitable. It's being lived in by the owner, so it isn't in that much disrepair, dare I say. I'm also disappointed that there's been no more serious consideration, therefore, of a different form of development, because quite rightly there is quite a lot of space there, and there would be the space for development that would be complementary to the older building and maybe able to retain it. So as I say, it's the cumulative effect that saddens me so much. But what I really want to focus upon is, as presented, we're going to gain some 11 households after losing 2. And we can possibly anticipate something like a 3-fold increase in vehicular traffic on what is effectively a cul-de-sac, a redundant bit of road. And although there are comments in the report about this road, the Planning Commission has previously been turned down because of the anxiety of the junction between Old Barry Road and, for the sake of the argument, New Barry Road. And please, members, don't be confused, because some of the things in the report are talking about conditions that are being applied to Old Barry Road, not New Barry Road. New Barry Road, if you choose to use the term, its speed limit was dropped some time ago, probably at the time of the Barons Court junction development, to 40 miles per hour. And it is that our highways officers seem to feel mitigates any difficulty getting in and out. Now, I don't know how well other members of the Planning Committee got in or out of Old Barry Road this morning, but I would argue that if you are there of an evening, as the traffic lights change, you might think you're in front of a drag race. Because regardless of the 40-mile-an-hour speed limit, it does seem that the signal green is the excuse to go as fast as you can to the next junction. And what I'm concerned by is that the only sensible way in and out of this road is by turning left, which means that people leaving have got to go off on some considerable journey before they can find a position to turn round and head off in the more likely direction. Or, if they're returning to their homes at night, having to go romping off somewhere else to find a means to turn round, so that they're making a left turn. So my position is that, although I accept the arguments for and again as put forward by our officers, I think the cumulative effect disappoints me greatly, and I really struggle to support this. But I would like to go back to Mrs. Honeybone's plea for her son, and I do understand that, and I do want to make sure, please, can we impose conditions of normal working hours from something like, I don't know, 8 till 4, Monday to Friday, except in exceptional conditions, because this site is not a domestic development. It's a significant demolition. If you go ahead, it is a significant demolition. There are several very large buildings to be demolished. That is not going to be a small and modest development like a loft extension, which might be what a domestic development would be. And then to rebuild 11 dwellings is going to be a significant building site. So please, can we impose some conditions so that if you are minded to support that the condition on sound protection is the best we can offer. Thank you very much indeed.
Thank you.
I don't feel I can support this. I'm asking you to weigh up what I've argued and see if you can agree with the officer's recommendations or not. I am struggling, colleagues.
Thank you for that heartfelt plea, Peter. Any other member? Because one or two of us went on a site visit this morning and we actually saw the site. John?
Yeah, question. Peter said there are no changes on the A4055, but actually the highways section does say there will be changes to the junction of Old Barry Road with the 4055, and I wanted to know what those changes will be. I appreciate what Peter said about, it's like a chariot race when the lights change, but that's how I got out this morning at the end of the site visit.
And I followed you out.
When the lights changed, the traffic flowed past, and then there was a gap because the traffic lights further down were on red. So it's doable.
Yeah. Well, I have to say that you stuck why the traffic passed, and I just followed you out, and there was no traffic behind. So I hear what Peter says. I suppose in rush hour times it might be quite bad, but I think where we came out at 11 o'clock in the morning, it wasn't that bad. Val Hartree. Can you put your traffic lights on? Lovely.
So I'm appalled that there's an application to demolish this building. I've lived in the area for 45, 50 years, and it is a prominent building. Standing up high, you can't miss it, and I think it's a shame. But I agree. I don't see why it can't be listed at this late date. But what appalls me is the access onto Old Barry Road, which I use a lot coming from Dinis Powys, from Tesco's more, if I may swear. And as soon as people turn left to go to Dinis Powys from Cogan, Cogan Hill, they belt like hell. He's quite right about it. And I wouldn't like to be accessing that road. And there could be 11 houses, there could be up to, probably not the 3 affordable, but there could be up to 30 cars using that. Maybe possibly working or going to go out at peak time, etc. And I'd like to know what they suggest changing the traffic lights to, because it is a speed track. I know it only too well, because my daughter was hit from behind in a car, you know, somebody going into her speeding too much. But what would there be a condition that they can only turn left? Because I have seen someone go out right there and risk their lives. It would have to be turning left, and right, they'd have to go up Redlands Road and come round and come back round. But that's their problem. I'm against this application completely.
Right. I think there are highways officers' comments, and they don't have a problem with it. But I think you wanted to say something about the vision display, don't you?
Well, what I was going to say is, in terms of Councillor Drysdale's question about the works along the Old Barry Road, there's actually a condition requiring full details of those. So I don't have details of the junction improvement. I don't believe they've been submitted yet. But obviously the indication is as Councillor King alluded to, improvements along that stretch of Old Barry Road. I don't believe there are any proposals for any works along the main Barry Road as it is.
At the junction.
Well, I think it's trying to describe that a scheme of works from the junction onwards. It may well include some some lining and possibly signing at that junction, but I don't have the full details in front of me. But I don't think there's an intention, for example, to introduce a no right or left turn or anything like that. Obviously, I would point out Old Barry Road is an adopted highway. It is an existing highway that is serving a number of properties already, not just the 2 on the existing site, but obviously a handful of other dwellings down the cul-de-sac. Completely accept the points that members have made, but we can't ignore the highway officers' comments who have assessed this. That it's their technical expertise that we are obliged to rely on these matters, and they are saying that they have no objection to the intensification of the use of this access. I agree with you that it's not ideal in terms of turning right during busy periods, and ourselves today we took a left out of the junction and did so, you know, relatively easily. You just have to wait for a gap in the traffic. There will be quiet times along the Barry Road, perhaps in the middle of the night, but there will be quiet times when it may be perfectly easy and safe to take a right hand turn. But ultimately members have to really rely on the highway officer's comments, the transport statements being submitted with the application that say that there is not a highway safety issue here.
Okay, Councillor Roberts.
Thank you, Chair. Two issues, really. First of all, it has to be accepted we have no right to protect Highlands, the old house. And it's a genuine question to the planners. Can we, but nonetheless, that doesn't stop us being responsible for the heritage of the whole of the Vale of Glamorgan, and we have that responsibility to society. So the fact that it's not listed and we don't have powers in that respect, does that really completely prevent us from trying to get a better scheme? Because it seems to me there would be easily a scheme here where you could have a number of these houses, the very same houses, perhaps reduced in number, and retain and use that to make the retention and repair of the old house viable. It's a genuine question, because I suspect the answer will be no, we don't have those powers, but it is such a shame to lose that house, albeit I fully accept we have no powers to protect it. So that's the one element. But the other element that worries me, we go back to traffic. If we look at page 140, apart from literally 5 words, the whole of the highways observations are on Old Barry Road. That's, frankly, irrelevant. Old Barry Road is a small cul-de-sac that used to be the main road through the Barry. It is no longer that. All the modifications the highways are looking at, apart from one four-word phrase at its junction with the A4055, relates to Old Barry Road. That's not the problem. The problem is the A4055. And you said we all left today. Yes, we did leave because the next site we were going to was on the left. But most people coming out of that development will want to turn right to go into Cardiff. And if they're forced to turn left, there is no easy way to turn back. you have to go considerable distance in order to find your way, because it is very difficult to turn right there. And although there is a 40 limit, it's really observed in its breach, because it, as Peter said, it's a wide 4-lane road, and you're either coming out to Dinas Powys, which is very congested, or you're coming off the Cogan Spur, which is also congested. So it's like a piece of free road where people let rip. So all of these statements here on page 140 relate to Old Barry Road, which is not where the problem is. And if you go back to page 136, planning in 1989 and 1990, 2 applications refused because of the effect on the main Barry Road, and they aren't addressed in the highway ones here. So there is a problem, and we'd be foolish to ignore it. We've just looked at Old Barry Road in the highways, and we haven't looked at the A4055, which was the reason it was refused twice in 1989 and 1990.
Yeah. Okay, I'll ask the planning officer to come back.
Thank you, Chair. The report does, in fact, deal with the difference here. So I'll draw your attention to the last but one paragraph on page 140. And this is specifically talking about that very issue. So it says the assessment and conclusions of the TS differ from those earlier planning applications. It's noted there's been material changes along the A4055, including the reduction in the speed limit to 40 miles an hour and the provision of traffic lights at the Barons Court Junction, which improves the access and egress to and from the Old Barry Road. The TS has also undertaken and notified that along that highway network, no recorded incidents of traffic accidents within the last 5 years. Now, I accept this is an intensification of that access, but it can't be ignored that there have been no accidents at that spot where there have been a number of houses already accessing that site via the Old Barry Road during that whole time, and there have been no recorded instances. So, you know, members need to be aware of those facts and take them into consideration.
Yeah, the problem for me, of course, is, and it happened earlier on the report, where the planning officer came here and was vocal to planning members, where you all took notice of him and voted down a scheme at Tonner Reading because the highways officer told you it was unsafe. Here we have a report where the highways officer is telling you it's safe, and now we're prepared to ignore it. And to me, you can't have it both ways. When he tells you it's unsafe, you vote against it, and then when he tells you it's safe, you're going to vote against it again. It just doesn't follow logic. Councillor Drysdale.
Thank you, Chair. It is a shame about the building. It's a very nice building. I wouldn't say it was wonderful, except for the round tower bit with the balcony, which is very, very nice. But we have to recognise what our remit is. It's private property. The owner can choose to do with it what they will, and I suspect the planning officer can tell me I'm wrong, but I suspect there is nothing we could do at this point which would remove the right of that owner to demolish that building should they so choose. So it is a shame, but I think that's kind of like water under the bridge.
Yeah.
That's obviously what the owner wants to do, and we actually don't have control to stop that. On the traffic side of it, yeah, it's not a great access onto the main road, but you know, we've used the word, it's an intensification of use, and the word kind of sends shivers. Intense, you know, even if it was 30 cars while I was sitting there waiting to get out onto Barry Road, 30 cars went past in the space of about 45 seconds. So it's not a lot of cars in the run of things, and they won't all be trying to get out at once anyway. Even if half of them are trying to get out in the rush hour, that's probably over a half-hour period. It's actually not that great an intensity, so we should be careful of perhaps the words we use or how we interpret them. It's a shame about the house, but it's a large site, and you know, it can take those houses and still not feel too crushed in, and I think we have no choice really but to approve it.
Councillor Jeff James.
Chairman, I think it's a sad day when if the planning committee feels they can do nothing else but go along with an application to which the application says to demolish the properties, but in effect, as has already been said, they're not listed and they're not in a conservation area, they could be demolished without a planning application. I think it's really sad that perhaps we haven't noticed this property much earlier and considered listing it, whether or not it is justified, whether CADA would agree to it. You know, it's all speculation, but it also seems to me that it's a prominent property, and there are many of them in the Penarth area, and slowly they're going. And it's a drip, drip, drip of significant properties in the Penarth area being demolished or changed in such a way as to be unrecognisable. And I think that maybe that what we ought to do as a planning committee is to review some of these significant buildings in the Vale before they're all gone. And you know, the new houses that replace it have no merit to match the house that's going to be demolished. So I think I'll vote against it, Chairman.
Thank you. Liz.
Thank you, Chair. Exactly as Councillor James says, it's a really difficult situation, and if we look at the responses to consultation on page 138, there's actually a really good comment where it says it deserves better than to be destroyed, especially as it can clearly be retained with new housing reserved to the gardens. We have it in a nutshell, but that's actually not the application that's in front of us today.
No.
We've got quite a number of very positive examples in Penarth. You know, Councillor James talked about some of the super houses that we have in the town. We've got an awful lot of examples. Well, we've got very good housing. We've also got a number where such complementary developments have been undertaken alongside them. But we have got an awful lot of examples of houses which have been allowed to go to rack and ruin in order to push the planning agenda. And when we're talking about something which is within the settlement boundary, so as we've heard, you know, there's a presumption of consent. If this goes to appeal and we lose it, we are arguably putting the Section 106 contribution at risk. Also, you know, arguably costs. And also say in terms of traffic, it is a busy road, but for many people like me that live on a main road around Penarth, I quite often sit outside my house for 5 minutes or sit in my drive for 5 minutes trying to get out through the traffic safely. It's one of the pressures of modern life, unfortunately, unless we all get onto buses. So I am really struggling on this one. The loss of any substantial and attractive house is a real struggle. But in terms of what we're being asked to do as a committee in applying planning policy in a local context, I don't think I can vote against. I think that I have to vote for.
Yeah, and those who are planning on voting against, I hope you've got a good planning reason to why you want to turn it down. Okay, I've got a number of speakers.
I did ask a genuine question at the start as well, and it wasn't rhetorical, is whether or not we have any powers whatsoever in respect of our heritage. I think I know what the answer is going to be, but I would like it answered. I don't, do you want me to remind you what I asked, Vicky? Sorry. Yeah. Okay, I do speak a lot. It's just that I said, I appreciate we may not have the powers to protect this property, but it is significant, and most people would like to save it, and there may be alternative plans where you could supplement the house with new ones. And I just wonder whether we have any powers whatsoever to try and steer it in that direction.
Thank you. Thank you for the prompt. It comes back to what Councillor Burnett has just said. that's not the proposal that's in front of us. We have to assess the proposal that's in front of us and whether or not that is acceptable. We can't keep going back and saying, oh, it would be nicer if it was this or if it was that. That's not what's in front of us. We've got to assess whether or not this is acceptable. Yeah. In terms of the loss of the existing building, it's not, it wasn't conjecture as to whether or not CADU would be prepared to list it. They have advised us that they do not think it is suitable for listing, so it's not going to get that statutory protection anytime soon, because CADU are the body responsible for that, and they've indicated they don't think that that's justified. So we are where we are with that. Whether or not the council could revisit its county treasure list and put it on a county treasure list, and that is something that would be within our gift to do, but obviously it would seem rather pointless given that the applicant has obviously given the intention that they want to demolish the application, and they could follow this. If you were minded to refuse the application, they could very swiftly put in a prior approval application for demolition tomorrow, and we would have to consider the reasonableness of the terms and conditions on which we could allow the demolition, because that is something that is permitted development. The only other power that we have is to serve an Article 4 direction on the property, and to remove the permitted development rights for demolition. And you will be aware that there is an Article 4 direction in place in part of Penarth already. That was done many years ago. I think it was probably back in the 90s, and it's been a very effective tool for us in dealing with the overall impact of the conservation area. We removed rights like changing windows and removing walls and so on and so forth. But that's not something that can be entered into lightly. It's not a process that we've done on an individual dwelling at any time in the last 20 years, I would say. And I can honestly say I don't know the precise procedure to follow, because it's not something that we do every day.
I think that's to be agreed by Welsh Government, doesn't it?
Yeah, I can't advise members off the cuff what the procedure would be for following that process, but clearly I would expect there to be a degree of input from the landowner themselves, whether that's through objection, appeal, possibly compensation and so on. So that is a potential avenue that could be explored in a bit more detail. But in view of the facts that we've already heard in terms of the state of the existing building being in a state of disrepair that would require some considerable investment on the part of the landowner to bring up to modern standards and to be suitable for redevelopment or residential use moving forward in the future, I think that would be to a degree unreasonable on our part, particularly when what we have in front of us is an otherwise acceptable scheme for the redevelopment of the site.
Okay, next with his hand up was Councillor Andrew Parker. Then I'll take Anthony Powell, then I'll take Nick Hodges.
Thank you, Chair. Just a small thing on condition 3. One of the ways you can improve coming out onto the main Barry Road would be to have a level section before you come out and improve the radius to the left-hand side. The level platform is a fairly normal thing and would allow you to get a better visibility to cars coming from Cardiff. We don't need to strengthen the condition, I'm just pointing it out and hope it'll be noted.
Okay, Councillor Powell.
Thank you, Chair. This is a real dilemma. I mean, I've been listening intently to everything that everybody has said, including the local residents and members around the table. And my heart says we mustn't allow this application to go through. But my head says that we need proper planning considerations to form our decision and the way we vote. And as I said at the beginning, this is a real dilemma. I agree with what Councillor James said with regards to perhaps we should have a review of all these wonderful buildings, and we should be making applications to have them listed. I would wholeheartedly support that. It's always a shame when you see your heritage being, dwindling away. But we didn't do that, and we are where we are. And unfortunately, you know, I find agreeing with my friend John that we have no grounds to refuse this application as much as we'd like to. And a dilemma as it may be, I will have to vote in favour of this application, as much as it pains me.
Okay, Councillor Nick Hodges.
Thank you, Chairman. On Channel 4 right now, there's a programme about heritage renewal, and in fact it covers a place in the centre of Barry, which of course is the pump house. I was told about it because the Vale of Glamorgan kindly tweeted me with the information, and I had to tweet back and said, I'm awfully sorry, I'll be in a planning committee looking at the possible knocking down of an iconic building in Penarth. The County Treasure Scheme is a joke. It offers no protection, and we have seen time after time buildings throughout the Vale that are getting changed or knocked down quite simply to bring forward schemes that are not friendly to the original dream of a county treasure. Now, I've got two questions. The first one is, under the highways, it's actually got a part here that says about various changes that need to be made to the length of Old Barry Road, signing, carriageway changes, street lighting facilities and things like that. Who's paying for that? And is that because to mitigate this building? If it is, why are we paying? And secondly, a question, and it's a serious question. We've been reading, I'm sure, that the developer, the owner, says he can't afford to repair the building, so therefore he's having this scheme instead. Well, I seem to remember a couple of years ago that we allowed small developments to allow Iweni Priory to get repaired. I know this is his application, but it would have been far more helpful and easier if we could have had a smaller, more sensitive scheme on the decent amount of available land there to enable those repairs to be made, if of course the developer is serious. So that's a question. Has that been approached, and would that be possible? If it would be, and if it is legal, and if it is sensible, and I know it was rare because we did it last time and it was rare, I would ask for a deferment in order for that to happen, those questions to be asked, and perhaps negotiations to be made. I am fed up, though, Chairman, of seeing prominent buildings of some age in the Vale of Glamorgan getting removed and knocked down willy-nilly, and this committee being absolutely powerless, it seems, to act. So I just ask those questions. Who's paying for the highway improvements, and is it because of this application? And also, is it possible to do something along the lines of Iweni Priory?
Just to confirm, any improvements required to Old Barry Road, conditioned by this application, would be payable by the developer and are required in association with this development. Obviously, they would have knock-on benefits for everybody using the Old Barry Road. In terms of the Iweni Priory, it's quite a different matter. That is a listed building, and enabling works were granted to allow works to that listed building, so that the listed building itself was secured and wasn't left to a state of disrepair. That is quite a different situation to this one, and I don't think they are directly comparable. If this was a listed building, we'd be having a very different conversation.
Yeah, there you are. Do you think we've had enough debate? Val Hartree, second time, Val?
But so other people have had second time.
I don't know about that, Val.
Well, I do.
Oh.
It just comes to mind. Remember the Ogmore development that was basically refused, and he knocked it down one Sunday? Yes. It's the sort of thing that can happen, and we're powerless. And I say I can't support it either. Microphone, Val.
Yeah. Yeah. It's been pointed out to me that some members left the room while they went to the toilet, which is perfectly acceptable. What we have to remember is, did we hear enough of the debate, and are we au fait in voting? I'm going to leave that to you. Oh, right, okay. Maureen Kelly-Owen.
Microphone, Maureen. Sorry. Thank you, Chairman. I'm going to say that on this particular occasion, with this old house, which I'm told is quite an important house, but not that important that it should be listed, I'm going to say that much as it hurts me to see it going, because I've known it since I was 5, I am going to go with the officer's recommendations.
Thank you for that, Maureen. You beat me to the microphone because I'm just about to put the vote.
Sorry.
I'm going to ask for a mover and a seconder first, as Margaret has pointed out. Are you going to move it, Margaret?
I'll move it.
There you are. Seconded by John Drysdale. Those in favour of officer's recommendation, please show. And, okay, counted those. Okay, and those against? And abstentions? 3 abstentions. What is the score? So, officer's recommendation then, because there were 9 for. Okay. Thank you for that. Right, we'll move swiftly on. The next one we visited in Penarth was the Tower Hill, Penarth. That's subject to late representations. That can be found on page 166. Would the officer like to lead us through the report?
Thank you, Chair. Just to draw members' attention then to the late representations. Firstly, it's late representation number 6, which I'm trying to find the page for you. On page 20 of the late representations bundle, this is a representation from an Anne Grigsby on behalf, who is a committee member of the Penarth Civic Society, who has objected to the proposed development for various reasons to do with impact on conservation area and listed building. This application that comes before us has been called in by Councillor Clive Williams due to the reason given opposition from local councillors and 11 people commenting on the online Penarth Daily News blog about this application. So the application is for works to a property known as, excuse me, I'll get the term right, the Tower on Tower Hill. For those of us that were at the site visit today, you could see that the main building, the tower itself, has already been extended probably some years ago with rather unsympathetic additions to it at the side and rear. Which are quite unsightly, and officers have obviously come to the view that what's being proposed is a considerable improvement on what is already there in the existing extensions to the tower. What's being proposed are various works set out on page 167, demolition of the existing extensions to the tower, construction of a new basement level comprising a store and gym, a single-storey flat-roof double garage set back from the front elevation of the tower on the eastern side of the property, French doors to the front south elevation and a covered terrace to the rear, a replacement flat-roof 2-storey extension on the east side elevation projecting to the rear, including a terrace to the rear at first floor, and replacement 3-storey flat-roof rear of the original tower. See, the plans are in front of you and copied in the report. The extensions are very contemporary in nature, which is considered to be an appropriate design response to this building. The building itself is not listed. It is a locally designated county treasure, and the site itself is immediately adjacent to, directly to the east of, the Grade 2 listed terrace of Tower Hill Avenue. There have been some representations that this would adversely impact on the listed road, but I think having been to the site today, members can appreciate that actually the two sites are quite visually distinct, this contemporary design response to the existing tower is considered to be appropriate and is not considered to have any harmful impact on the listed terrace. It is also within a conservation area, obviously, so we have to take account of the impact on the conservation area, but officers are of the view that this is actually a really good scheme that will vastly improve the existing setting of the tower.
Well, we haven't got Councillor Williams here, who called it to committee, and he didn't turn up at the site visit either. But notwithstanding that, I'll ask one of the local councillors, Councillor Gwyn Roberts, who did go to the site visit and is present tonight.
Thank the Chair.
Yeah.
Thank you, Chair. I visited. The fact that it's a county treasure, in a way, almost demonstrates the fertility of that system, because there is an old I think it's a Coast Guard tower. It was initially. It's a county treasure. It is a beautiful building, but at this present time, it's completely enveloped by the hideous 1970s, 80s development. Totally unsympathetic. Differing windows all around that completely dominate the building. This proposal now actually is superb. It removes all those hideous carbuncles that are attached to it, and the modern way it's done, and dark wood or natural wood allows the tower in as it was originally built to be seen. So I think it's actually a vast improvement, and it now effectively makes the tower justifiable as a treasure. So I think it's a vast improvement. I'm probably going to incur the wrath of the Penarth Daily News and all its contributors, but there we go.
Well, what they know about planning, you can put on a postage stamp.
Well, that's nothing new, Chair. I haven't had criticism for days, so
yeah.
So I'm missing it. But basically, I moved the officer's recommendation. Oh, by the way, I just would say the Penarth Council, in fact, objected to it, but the chair of the planning committee is there, and his view today was that was a mistake. We didn't realise it was all this. So even that objection would effectively be discontinued. So I move the recommendation, Chair.
Yeah, I think many people around the table have the same sentiments, and I'm surprised that the... You can, yes. Seconded by Councillor Maury Kelly-Owen. I was just going to say that I have read the supplements on the Penarth Daily News, and they obviously haven't read the officer's report or gone to the site and looked at that building in its present condition, because anybody can see that whatever happens to that building, even demolition, would be an improvement on what is existing. So I'm with you, all the committee. I think this is the first time we can all agree on something.
No, it don't mean there is.
Oh, right.
Mean there is.
Oh, no, I forgot about the ones at the far end. The others on the dark side. Yeah.
Right, is there any more
comments? Yeah.
Any more comments?
Okay, it's been moved and seconded, hasn't it?
Yeah.
Yeah. Those in favour of the officer's recommendation, please show. Wow. Yeah. I think I'm going to have to make an apology in public here.
Chris had his hand up first before anybody
He did.
else.
Yes, Chris Franks was first up. So that was unanimously carried. Well done. Thanks very much for that. Right, the most contentious piece on the planning agenda tonight is the Dinis Powys service station. No, we got Church Cottage, a Berthin.
Yeah.
Yeah, we mustn't miss that out, because that was called to committee by Councillor Andrew Parker, and we went along on a site visit. I know there's some late representations, and it can all be found on page 182. Over to the planning officer to lead us through the report.
Thank you, Chair. Just to draw your attention then to the late representations, which are on... I got this, page 22 of the bundle. We've had extra comments from the highway development section, and the officer's response to that is to suggest another couple of conditions which are set out in the late representations. So to add conditions relating to the visibility displays, the full engineering details, and not taking the precise wording of the highway officer's recommended construction traffic management plan condition, but rather suggesting a construction environmental management plan, which is our standard planning type condition. The highway officers have also recommended condition survey be undertaken in respect of the highways adjacent to the site. In the late reps, you'll see the officer's response to that is that we feel that that would be unreasonable and overly onerous, so we're not recommending that that condition be imposed. And then we also have had further comments from the Cowbridge with Llanplethian Town Council, who've objected to the proposal by reason of overdevelopment of the site, impact on the conservation area being out of character with the area, overlooking and loss of privacy issues. So that's all available in the late reps, so hopefully members have already had a chance to read through those. If I can briefly cover the report then, this application is for a development site within the settlement boundary of Aberthin, but it's on the edge, so this represents the sort of last plot at that end of the Aberthin settlement boundary. Part of the site, mainly being the front northwest corner of the site, lies within the conservation area, so obviously so do some of the adjacent properties opposite and to the east of the site. The proposal is to demolish the existing cottage which sits on the site, which is shown on the plan on the screen, marked in green with some outbuildings, to demolish that and to replace it with 2 4-bedroom detached dwellings. Also the creation of a new access at the front of the site, and similar to the property we considered earlier in Aberthin, this site slopes quite steeply up from the road, so the proposal involves quite a lot of cut and levelling of the ground to enable these 2 properties to be built and to provide the new access at the front of the site and parking areas there. You can see from the plans up on the screen the differences in levels that we're talking about. The officer's recommendation is for approval of this application with, bear with me, with the Section 106 agreement, details of which are on page 198. So that's a contribution of £57,211 towards the provision of affordable off-site affordable housing, which is in accordance with our new requirements for a net gain of 1 dwelling in areas like this for provision of affordable housing. Obviously, all the issues that have been raised by neighbours, in particular in terms of the visual impact, the impact on the conservation area and impact on any neighbouring properties, have been covered thoroughly in the report.
Okay, call to committee by Andrew Parker. Let's have his thoughts.
Thank you, Chair. This application has been in several times, and in fact I can remember when Hayley Kemp was looking after it first of all, and quite clearly it was rightly refused then. I would now compliment, and I actually do mean that word, the planning department on actually achieving a reasonably good scheme on a very difficult site. Clearly it would go against a lot of the people living in Aberthin, but sooner or later these sites have to be developed. And on that basis, I think you've now achieved the right sort of scheme. One thing I would say, though, is picking up on Paul Harrison's condition 4, which you've asked to remove on a condition survey. The amount of excavation of this site will mean that machines will be going across the highway to actually dig into the site, and undoubtedly damage will be done, and to a certain extent the fact that it's conditioned that damage can be repaired, and they have better powers with a condition as condition 4 on page 22, that is. I would prefer to leave that in.
If I can just come back on that last point, it's quite rare that we've used those conditions. I can think of one when we were dealing with the very large development at Ogmore, where the access to the site was quite difficult, that we did impose that sort of condition. But on the whole, these types of applications, we don't impose those conditions. We didn't, for example, earlier on the one we considered this evening at Penland, where again we were talking about quite a lot of excavation. If damage is caused to the Highway Authority do have powers in their own right to take action, and it would be pretty obvious what the cause of that damage would be. So I would rather leave it to the Highway Authority to use their powers if they see fit, rather than impose a condition that I don't honestly think is reasonable.
I'll take that, and as ward member, I'll keep an eye on it anyhow. So maybe I'll do a slightly more thorough job. Well, that's true, but we're not so worried as you.
That was a bit under the belt. He started it, yeah. Okay, we're getting into elections. Right, okay. Does any other member want a burning desire to speak on this? Otherwise, I'll go straight. You'll move it, and there's a seconder over there. So it's been moved and seconded. Those voting in officer's favour for approval, please show. Okay, that's unanimous, except we got one extension with Andrew Parker. Okay, now we get on to the serious stuff. This is the tower in Dinis Powys on the service station, Cardiff Road, Dinis Powys, which has got late representation. I don't know whether there was a speaker. There was a speaker.
She's not here.
She's not turned up. So we'll go straight into the debate. I think the officer's going to tell you normally these wouldn't come to planning committee because there's regulations by government that's in the statute book that we wouldn't have to consider. But it has been called to committee and we need to consider it. Okay, Vicky.
Thank you, Chair. Yeah, just to draw members' attention to the last of the late reps for this evening, which is an objection from a neighbouring occupier at 63 Cardiff Road, who has raised a number of issues of objection in relation to this. Okay, so as the Chair has alluded to, this application has come before you at the request of Councillor Hartree due to the number of objections that have been received. These types of applications are not normally reported to Planning Committee because they're covered by the scheme of delegation, but also because of the type and nature of the application that it is, it's a prior notification of telecommunications under the General Permitted Development Order, which essentially means that these works are permitted development and that the only matters before us that are for consideration are the acceptability of the siting and appearance of the equipment. So those are the only matters that members can really consider and be thinking about. Obviously, representations have been made in respect of possible health impacts, noise and disturbance, those sort of things. Now, the impacts can be taken into account, but only insofar as we're talking about the appearance and siting of these types of developments. So it's basically to let you know that there is that caveat to what we are able to consider. I'd also draw members' consideration to page 213. The recommendation here is somewhat unusual, and that's because of the nature of the application and the call-in request. These applications have to be determined within a set time, and if we don't determine them, then they're deemed to be granted anyway. So we've brought this for you to this committee because there was time available to do so, but it's before the expiration of the consultation period. Consultation responses might be received up to the 10th of April, which is before the determination date that we're required to satisfy, which is the 26th of April, but obviously that would be before the next available planning committee. So the recommendation is that if you agree with officer's recommendation, prior approval is not required for this development, subject to the head of regeneration and planning or operational manager for development management, in consultation with the chair of planning committee, be given delegated power to amend that decision if any consultation responses are received after tonight's meeting within the time frame which alter that recommendation. So essentially you're giving back the delegation to myself or Marcus along with Fred to change the committee's decision this evening if there's anything that comes to light that warrants it. The plans before you show the size and location of the I think it's called a monopole, of the telecommunications mast. It's 15-metre high, it is monopole, with shrouded antennae and a diameter dish and 2 equipment cabinets. They're sited on the very edge of the perimeter of the petrol station forecourt, adjacent to residential properties. this is not a conservation area. There's no listed buildings close by. In terms of its sensitivity, the site really needs to be viewed in its context, in terms of it being a petrol forecourt, you know, adjacent to a highway where you have normal paraphernalia like lampposts and things like that. And this is, you know, the officer's recommendation is that the prior approval is not required, because we don't feel it's the type of site or location where those sort of details would be justified to require.
Okay. I know Councillor Chris Franks welcomes it because his strength of his signal is very poor where he is. Yeah. He'll answer his phone to us in quicker time. Anyhow, Val, you brought it to attention, so what would you like to say?
Well, I'm not happy with this, but I have to say, as a member of Dinas Powys Community Council, I'm disappointed there hasn't been a response so far at the time of writing. However, and my husband is chairman of that planning committee, so I'm certainly not happy about it.
Oh,
but
God.
they had difficulty in forming a quorum, because we have some very rich people who are always on holiday, and they couldn't get a quorum on their planning committee. But I would say that I'm obviously very familiar. I live on Cardiff Road, but these proposals, if people want good reception, etc., they have to be accommodated. But nobody likes them. And in my experience in Penarth, for example, they go ahead whether we like them or not. But whether this is an acceptable location, though I do realise, and it's listed in my husband's papers, that they have tried about 8 or 9 sites, and their reasons for rejecting them, etc., etc. Now, the neighbour, most of the objections that were rung through to me and emailed to me were basically things, health and safety, etc., these perceived damage done, and also would it affect their television reception, but I didn't think that was a serious one. So the site has limited residential property, you know, well, immediately, 7 metres to the left of it. So I don't think it's limited residential. Cardiff Road is a very heavy residential area. But it is a very busy stretch of road, and it will be a prominent feature for people coming from the east. It's also likely to be visible to traffic coming from along Cardiff Road from the west. You know, and I think we have to, on behalf of the council, I will speak to them, have to voice concerns about the visual impact and potential, you know. So is it worth asking 2 questions? But can I divert from there and see the late representations from the next door neighbour to say one site that wasn't included in all the list that was in Dinas Powys Council's papers, we should ask them, did they consider citing it on the old Vale storage units as you come into Station Road from Barry? That wasn't one of their sites. So I would think, they know their coverage better than me, obviously, but I think it could be, should be investigated before we approve this. And you see, that is also near, as you know, Station Road comes onto Cardiff Road opposite East Dinas Powys Station. That site should be investigated. What do we call them normally? Storage units, the council depot? The council depot at Dinas Powys. I would like their views on that. It's a matter of what? Vicky, would you guess the distance from Greenfield Avenue through to? No. Half a mile max. I mean, they investigated different sites which are probably about the same distance away, and I would like to know their views on that particular site. And also, if it were inevitable that this should be sited here, I pasted out today 10 metres is not very far from the road, and there's going to be a cabin at either side. Could it, if it's inevitable it goes there, it could go to the back of the site, outer site. It will still be visible because of the height of the damn thing. And also, could the overall height be reduced somewhat? It's going to be visible wherever, but you know, it's not on as far as I'm concerned. Two others were suggested, but they've already been looked at by the developers or whatever you want to call them. So I'm not happy with it. A lot of people aren't happy with it, and I will vote against it.
Okay, Councillor Argies.
beg your...
Thank you, Chairman. I've got a bit of experience with these masts at the moment in my ward. What amazes me, first of all, this is just a comment. What amazes me is that the companies don't actually come to the local members, perhaps, and say, "What do you think? And could you suggest a better place?" Because it would actually do. I think they get their applications through easier, quicker, and far more acceptably. The issue I've got on this one is that it's 6 metres from the side of this house. I think that's totally unacceptable. And as they say themselves, the overall height of the proposed pole at 15 metres is set at the minimum required to clear surrounding clutter and not to be overbearing in the skyline. Well, if they want to clear it, perhaps they shouldn't build it 6 metres away from a house. There are plenty of other sites available in Dinas Powys, including, I would suggest, probably areas along the railway line, which would probably be less obtrusive and would probably just have as good a coverage. The other thing I've noticed is the various companies that are applying now to put these poles in all sorts of places is they want to go very, very, very close to a highway, and they're doing that for their own ease of electrical connections. Now, I appreciate that we all want a better signal. However, these are private companies, and if they have to spend a bit more money in actually getting their connections and it's a bit more difficult for them, well, so what? They need to be good neighbours in their business. I find the picture on 207, page 207, the proposed elevation from Cardiff Road is incredible, and the closeness to the house and the way it literally overbears that house is unacceptable in my mind. Now, I appreciate the way that the application comes in. We've had one changed in Barry. We've also had another one which is currently going through pre-application discussions. Both of those, well, if, like I said, they'd discussed things better with us, they'd probably get sorted better. But this one I find to be absolutely ridiculous, and surely, even at this stage, there can be discussions with these providers that a more acceptable site could be found. I don't know if I'm allowed to vote against it. It's bizarre, and I'm thinking we're being rode roughshod over with applications like this. But this is, if it was a garage in the middle of nowhere, I'd have no problem. But it's a garage next to a house, as close as that. It's 6 metres away, and it's probably twice the height of the house. I can't agree to it, Chairman.
Val?
Can we request that they look at this other site that's been suggested?
No.
Or not?
No.
Well, they've
It's a planning application, and you have to determine the planning application. You can't go along and say, "Oh, we've got these other sites for you."
Well, it's a pity they didn't think of the site
Yeah,
themselves.
let the officer come back and answer it.
Because these, you know, there is this presumption in favour of this type of development. That's why they're permitted development. You know, just like conservatories and sheds and things like that are permitted development. You think we have zero control over those. This is just for us to control things like how it appears. So, for example, I can recall one that I think we had in Cowbridge Conservation Area where we insisted that it was painted black to match the street furniture there. It's those sort of controls that we can impose. What they do have to demonstrate is that they have considered alternatives, and that's why you've got the list that's been brought to our attention. But we can't say to them, go and have a look at this site, go and have a look at that site. That's not good enough. What we've got to consider is what's in front of us and whether or not that's acceptable.
Back. If I could come back, it's just to say you've got one pole in Cowbridge painted what colour? Black. Well, black would be very unsightly against the white side of this house, so maybe we could suggest, you know, the rest of it. What it goes white. What?
Yeah. Okay, we've had a good debate about it. We've got the representations. We've heard what Val has said. I'm going to move that we approve this mast from the chair. Have I got a seconder? Councillor Powell. There we are. Those in favour, please show. Yeah, good boy. You wouldn't get a signal. Okay, have you got those? Those against? 3. Thank you. Any abstentions? No, that's clearly carried. Thank you for your forbearance, and we'll see you at the next planning meeting.